project. I'm just here today to welcome you, to provide you with some context for today's event, and to introduce you then to Professor Dagmar Sheik, who will in turn introduce the speakers for what promises to be, I think, a very interesting, but also a very important discussion at a very interesting time, at least for the island of Ireland and for Ukraine as well. So, just to give you a sense of this programme, which is offered by the Jean Monnet Centre of Excellence, its sub-theme is EU integration and citizens' rights. And it really, what it aims to do is to illustrate whether citizens' EU-derived rights contribute to the EU's legitimacy. So the focus in that context is on practical usage and the perception of rights derived from EU law, applying within the EU, within its neighbourhood, and globally as well. So today's seminar promises to explore the extent to which the EU effectively promotes anti-discrimination rights in its neighbourhood, using Northern Ireland as part of the new Western neighbourhood, and then of course Ukraine as part of the Eastern neighbourhood as case studies and examples for this project. And it's about combining practical and academic approaches on the integrative capacity of EU anti-discrimination law in the face of what we're beginning to see as increasingly significant far-right populist challenges, which will, of course, perhaps more than likely crystallise even more so in the months and possibly the years to come. So it's my pleasure to introduce Professor Dagmar Sheik to welcome you further. But before I do, there are some rules I have to read out. Forgive me. Just in relation to exits and fire assembly points, 3 exits in this event room, 1 at the back of the room and 2 at the side. I sound like I'm on an Aer Lingus flight. You can leave through this door towards the exit, and the fire assembly point is across the street. Toilets then are just out past the main reception. So thanks very much for your attention, and I look forward to engaging with you again during the moderated discussion. But for now, Professor Dagmar Sheik.
Yeah, that's better. Thank you for these words. And I'm just shortly introducing the seminar because I realize that we are behind time already before I've said anything. So next slide, please. This academic seminar really engages with 3 different levels. First, there's anti-discrimination law and policy, one of the flagships of European Union integration, a rights policy. And second, we venture beyond the European Union, because European integration doesn't stop at the borders. It never did. And so we explore the neighborhood. And thirdly, we compare the outermost eastern and outermost western parts of the neighborhood, Ukraine and Northern Ireland. Although Northern Ireland is a state-led rather than a state. And we also compare 2 regions mired in ethnic conflict by doing so. So next slide, please. European anti-discrimination law, flagship of EU's human rights policy in the 1970s relating to gender, and then from 2000 relating to disability rights, ethnic and racial discrimination, LGBT rights, age discrimination, religious discrimination. I think I have them all now. Now, yet the flagship may no longer be as modern in 2024 as a quarter of a century ago. EU anti-discrimination directives are focused on prohibiting specific behaviors, such as direct discrimination, indirect discrimination, and also the refusal of accommodating reasonable differences in the case of disabled persons. They are just structurally reactive rather than proactive. And while they give some scope for group litigations, they don't require the member states to allow it. They do require the member states to install equality bodies, such as the IRL, and they allow member states to adopt positive action. We can see that as a kind of proactivity. But so when it comes to promoting anti-discrimination on the neighborhood, the EU could be accused of imposing an outdated model instead of demanding the development of more forward-looking models to achieve equality within and beyond its borders. Going to the next slide with our neighborhood, one might question why the EU is promoting rights. The neighborhood was introduced as a concept with the Lisbon Treaty in when was that again? 2009, ages ago. And Article 8 of the EU treaty is on the slide. It requires the Union to develop a special relationship with its neighborhood based on its values, and more importantly, on agreements with those neighboring states. The UK has moved itself from the EU. It hasn't removed itself from the EU neighborhood because it remains the Western neighbor, and it couldn't remove themselves from the EU neighborhood. So, and the values of the EU include protection from discrimination. That's Article 2 and Article 1 of the TEU. So it's no surprise that anti-discrimination laws are part of neighborhood agreements. However, neighborliness is part of the EU's external policy, where agreements are concluded with countries. International agreements with third countries, in principle, lack direct effect and supremacy. And I'm hoping Rory is going to contradict me and tell him it's all working well in Northern Ireland. So how can human rights dimension of EU external policy attain credence? That's our second question. Now with our next slide, the Northern Ireland and Ukraine are two regions mired in conflict. For Northern Ireland, it's a matter of dispute whether the conflict is actually an ethnic conflict. I think it is, but I'm a minority there. In Ukraine, there are ethnic diversities, the Ukrainian and Russians. And in conflicts mired in conflict of a specific kind, other ethnic conflicts with other minorities, but also other social problems are often pushed to the background. But there is more reason to introduce policies for gender equality, which includes equality for those who defy gender stereotypes by living alternative lives as lesbians, gay, bisexual, or non-binary peoples. Rights of disabled people are another category prone to be pushed into the background, perhaps with the exception of those who suffered in the conflict. So that's why I think this comparison is so important. Even after the seminar, which is the second on comparing Northern Ireland and Ukraine, you can find the other one back on our webpage. Research questions will remain. I've already mentioned LGBT rights. And at that regard, we need to be reminded of the Northern Irish Asha's Bakery case, where one of the leading Northern Irish equality lawyers was part of the legal team for the bakery, refusing to bake a gay marriage cake, while the Equality Commission Northern Ireland defended the bakers, the gay couple. Both regions offer ample scope for LGBT rights to be utilized by the religious far right as an argument that this is an alien import. And that's something which needs to be explored. And as we also have one comment on the dimension of racial and ethnic discrimination in both countries, more needs to be done in this area as well. So I now come to introduce our speakers. Professor Rory O'Connell comes to us from Ulster University, and there's more words on the slides, and I'm going to save kind of time. And in addition to what you can read, he has co-authored a study for the Northern Irish Human Rights Commission on the protection of rights under what is now called the Windsor framework, including discrimination rights. We've got Maria Jasenovska, that's better. She's an activist and expert on human rights with a focus on disability rights and with more than 20 years experience in the NGO sector. And then we have Irina Tekoshova, who is a PhD candidate at Maynooth University with the ERC Dancing Project, working on rights of persons with disabilities in EU external relations with a focus on Ukraine. I think you're both from Ukraine as well, originally. So do we have Dr. Ibn Yusuf, or has she cancelled? Anyway, she was giving a comment, and let's see whether she turns up, because she was a race relation consultant and director of the Institute for Anti-Racism and Black Studies. So that's our speakers, and now I give the floor without further ado to Rory. And perhaps he gets a welcome, huh? Yeah. Yeah, people get applause before they speak.
Thank you very much, Dagmar, for the invitation. Thanks, Mary, for the welcome. And thanks also to Eric for hosting us today. It's a pleasure to be here. And I should start by saying that I am going to be speaking. This paper is based on research that I'm doing with my colleagues, Dr. Sarah Craig and Dr. Claire Lugar at Ulster University, on behalf of the Equality Commission for Northern Ireland, the Northern Ireland Human Rights Commission, and indeed the Irish Human Rights and Equality Commission. So I want to talk about the challenges that Brexit has posed for equality and equality and rights more broadly in Northern Ireland, outline the solution found in the withdrawal agreement, the protocol, the Windsor framework for those challenges, and then highlight some of the potential problems with the solution. So in terms of Brexit and the challenges that this posed for Northern Ireland, for the special, indeed the unique circumstances of Northern Ireland, funnily enough, I was on my way to a meeting in this building the morning after the Brexit referendum, and I still remember the sense of shock when the decision came through and the realization that nobody had thought about what the implication, or almost nobody had thought about what would be the implications for Northern Ireland. Which very quickly became apparent, especially in relation to matters around free movement of goods, trade, customs, how to deal with this border, a pile of dirt in the middle of a road somewhere in the border regions, but also issues about human rights and equality and the peace process as protected in the Good Friday or Belfast Agreement. So there was concern about whether or not Brexit would unsettle or even violate, I usually say unsettle, the Good Friday or Belfast Agreement. And part of this concerned the issues around the protections for rights and equality in the Good Friday or Belfast Agreement. The agreement contains extensive provisions around rights and equality and safeguards, and European Union law has been seen as underpinning the agreement, indeed the wider peace process, and the rights and equality provisions of the agreement. So EU law has been important, whether it's been through the Charter of Fundamental Rights, through general principles of law, through specific directives on equality and rights, and in particular, 6 core anti-discrimination directives. Those directives were important in a number of ways in Northern Ireland, in ensuring that there were certain minimum standards of rights protection north and south, because they provided a minimum set of protections. In providing an understanding of equality law that got out of the tendency that we have in Northern Ireland to see everything in terms of unionist or nationalist, green or orange politics. And also, very crucially, the European equality law enabled us to make progress in relation to equality in the first part of this century, in the context that, as we know notoriously, the Northern Irish institutions have been operational for about as long as they've been non-operational since 1999. And more worryingly, perhaps even when they are operational, they are subject to power sharing, consociational mutual vetoes, which give key players the possibility to stymie change. And so, for instance, we had the situation whereby the largest unionist party, its leader at one point was opposed to EU law that dealt with issues around gender and transgender issues. But because of supremacy and direct effect, the UK government felt obliged to legislate for EU equality law over the head of the Northern Ireland executive. So all of that leaves us with the question then, well, what was going to happen once the UK left the European Union? And the solution was found in Article 2 of the protocol, now the Windsor Framework, on rights of individuals. And Article 2 of the protocol or Windsor Framework provides for the non-diminution of rights. So there is an obligation on the UK to ensure non-diminution of rights stemming from the UK's exit from the European Union. The article also requires the UK to help facilitate the work of the Equality Commission and the Human Rights Commission in the North, and the Joint Committee of the Human Rights Commissions on the island of Ireland. So this Article 2, embedded in the protocol, the Windsor Framework, itself part of the withdrawal agreement, means that Northern Ireland is still subject to, or benefits from, if you prefer, European Union anti-discrimination law, and to a certain degree, wider human rights protections. By virtue of Article 4 of the withdrawal agreement, the agreement shall have the same legal effects in the UK as in the European Union and the European Union member states, which means that there must be a degree of entrenchment provided. In addition, Article 13 of the Windsor Framework provides that the Union Acts specified in the agreement, Union Acts specified in the protocol shall be interpreted as they are applied, as they're amended, or as they are replaced in the European Union legal order. And there is an obligation to apply European Union legal concepts in conformity with the case law of the Court of Justice of the European Union. The effect of Article 2, you'll note, is to create two types of non-diminution. The first is called the keeping pace requirement or the dynamic alignment requirement. And this applies to specifically 6 directives, which are core anti-discrimination directives listed in Annex 1, covering gender discrimination, race discrimination, and the General Framework Directive on religion or belief, age, disability, or sexual orientation. So here we have a keeping pace requirement. If these directives are amended in the European Union, the UK has undertaken to amend Northern Irish law to keep pace with those developments in the Union and replicate those effects in Northern Ireland. There is also a version of static alignment. So where you had European Union law in effect in Northern Ireland prior to the end of the transition period, which underpinned rights in the rights, safeguards, and equality of opportunity part of the Good Friday or Belfast Agreement, then the UK must ensure there's no diminution of those standards as they obtained prior to the end of the transition period. So we have two types of alignment, dynamic and static. Now, all of this may sound hopefully interesting, hopefully forceful and effective. It does mean that there are certain protections for equality rights in Northern Ireland, those stemming from the EU legal system, that no longer exist in the rest of the United Kingdom. Nevertheless, there are many challenges with this. Dagmar asked me, would I say that everything is hunky-dory in Northern Ireland? I never say everything is hunky-dory in Northern Ireland. So that and it's still early days, right? We're still waiting on cases coming through the system dealing with Article 2. As I'll mention at the end, we do have a couple of interesting cases so far decided specifically on Article 2. But we are waiting for a lot of clarification still on what all of this means. So there are challenges. There is, first of all, real risk, it seems to me, that Article 2 may be dragged into the sort of zero-sum political game that the rest of the protocol or framework has been dragged into in the past few years, and that led, of course, to the effective suspension of the institutions in 2022 until just this week. Thankfully, to date, there has been very little political controversy about Article 2, but this is starting to change literally in the last few weeks with some unionist commentators and politicians picking up on the fact that Article 2 seems to create a legal border in the Irish Sea to match the Irish Sea border in the trade of goods. Second, there is also a risk, perhaps, that UK institutions may decide to ignore their international obligations, in that it has been a feature of the UK governments since the Johnson premiership that has been willing to countenance passing legislation to exempt the UK from its international obligations. And we saw that in the original version of the UK Internal Market Bill. We saw that in the Northern Ireland Protocol Bill. Both of those were either amended or, in the case of the Protocol Bill, withdrawn. So the powers the UK government sought to give itself to exempt itself from international obligations didn't come to pass. But we also see the UK government increasingly getting Parliament to pass legislation which disapplies part of the Human Rights Act, which is the act that is the main protection for human rights in the UK, including Northern Ireland. Most recently in the Safety of Rwanda Bill, where there is a quite compendious effort to exclude the operation of the Human Rights Act from cases involving the removal of certain migrants to Rwanda. Third, there are problems about the way that Annex 1 makes a distinction, Article 2 makes a distinction between the Annex 1 directives and other directives. So this means that there is a distinction in Article 2 and Annex 1 between, for instance, the gender equality directives, which are included in Annex 1, and directives around matters like parental leave or work-life balance, which aren't listed in Annex 1. If you think that equality requires certain structural adjustments, for instance, and not just dealing with direct and indirect discrimination, but dealing with issues around care and work-life balance, then we have a problem that parental leave is not listed in Annex 1, and of course the work-life balance directive is not listed in Annex 1. It could lead us with the slightly bizarre situation that Northern Ireland is required to remain aligned to the provisions of the parental leave directive, insofar as they underpin rights in the Good Friday Agreement, even if the European Union has moved beyond that. Fourth, Article 2 is not subject to the so-called democratic safeguard provisions in either the original protocol or in the Windsor Framework. So the original protocol allowed and allows the Northern Ireland Assembly to decide to end the application of Articles 5 to 10 of the protocol framework to Northern Ireland in a vote every 4 years. But that doesn't apply to Article 2. And the Windsor Framework introduces a so-called stormont break that allows the UK government to veto the application of changes to EU laws that would amend a directive listed in one of the annexes to the protocol, to the Windsor Framework, mimicking the so-called petition of concern procedure in the Northern Irish Assembly. In one sense, of course, this means the equality directives and Article 2 are given a certain degree of enhanced protection, but it may also raise issues about the democratic legitimacy of Article 2 compared to the rest of the protocol or framework. And finally, there are still lots of ambiguities, both in relation to Article 2 and in relation to what is included in the rights, safeguards and equality of opportunity part of the Good Friday or Belfast Agreement. So these are where we are waiting for court cases to tease things out. Already we know that there is quite a gulf, difference of opinion between, say, the Human Rights Commission and the Equality Commission in Northern Ireland and the UK government as to just what falls within the scope of Article 2. Do, for instance, things like the Reception Directive and the Qualification Directive, do these fall under the static alignment implications of Article 2 or not? The UK government says no. The Commission seems to believe that it does. And even just last week in its Safeguarding the Union paper, the UK government puts forward a really remarkably narrow interpretation of the protocol or framework in its very scant references to Article 2 of the framework. In the command paper Safeguarding the Union, it implies that the protocol, the Windsor Framework, only deals with free movement of goods, which seems to entirely miss the point about Article 2. So there's differences of opinion. Of course, all of these will need to be worked out in litigation. One of the implications of the withdrawal agreement and the protocol Windsor Framework is that Article 2 is directly effective and can be relied on in the courts. And so we have litigation. And we have two interesting cases so far in Northern Ireland. One, and this goes back to what Dagmar was alluding to earlier in relation to the far right making use of the law in order to challenge equality measures. One was a case brought by the Society for the Protection of the Unborn Child, SPUC, who challenged the lawfulness of changes to Northern Irish abortion law, which, among other things, authorised abortions in cases of where a fetus would be born with severe disabilities. And SPUC, through their counsel, it was the former Attorney General, John Larkin of Northern Ireland, argued that this would breach Article 2, because according to SPUC and Mr. Larkin, the Convention on the Rights of Persons with Disabilities is part of European Union law. It's an international treaty ratified by the European Union. And according to their argument, it prohibited abortion in those circumstances where it was specifically related to a fetus having severe disability. The courts rejected that argument. They did accept that Article 2 could be relied on. They set out a very detailed test as to what Article 2 entailed. They accepted, it seems, that the Convention on the Rights of Persons with Disabilities to a degree is part of union law that is protected by Article 2 of the Windsor Framework. Where SPUC failed was because the Convention on the Rights of Persons with Disabilities could only apply within the competence of EU law. And according to the courts, EU law was not generally competent to regulate abortion in the member states. So there was no EU competence to regulate abortion generally, and so the argument failed. A second case where the courts have dealt with Article 2, which is also an interesting one, is where we had an asylum seeker who was removed from Northern Ireland, first to Scotland and then England. It's really quite upsetting reading these tales. This person doesn't read or speak English, receives a letter informing him that he's to be removed from Northern Ireland across the sea to Scotland the next day. So fortunately, he did manage to get his counsel and did manage to get some litigation going. And the courts accepted that he could invoke Article 2. The courts accepted that in principle, he could invoke references to rights in the Charter of Fundamental Rights and rights in the Reception Directive, I think in that case. Again, fell down on the actual application of the EU law, his specific facts. So he didn't win the case, but the courts did accept that in principle, he was within the scope of Article 2. And importantly, very importantly, the court rejected an argument put forward by the Home Department that the Good Friday Agreement really only dealt with rights in the context of conflict resolution as understood in 1998. So the Home Department tried to argue, and the government, UK government has tried to argue this in other fora, that you have to understand the Good Friday Agreement, the Belfast Agreement, in the context of ending the conflict in 1998. And so it doesn't really have any application to other types of human rights issues like the treatment of asylum seekers. The court robustly rejected this, saying that the Good Friday Agreement was intended to protect the human rights of everyone in the community, even outside of communal conflict. It's still early days in terms of the application of Article 2, but I personally would hope that this at least provides some sort of illumination as to how the courts, the Northern Irish courts, will interpret and apply Article 2 in the future. So, thank you.
Like Marina gives us a break from the slides, I think. Oh, yeah. You speak from the front, because that's easier to hear you. Maria, sorry.
Everything's fine. Hello, everyone. I'm happy to be here. My name is Maria Yasinovska. I'm working now in European Disability Forum as a Human Rights Officer International Cooperation. But before, as you mentioned, I'm from Ukraine. And I think I still a Ukrainian human rights defender. And I worked a lot with the topic of discrimination, and some years was the head of all Ukrainian coalition against discrimination. And it's a very big surprise for me to have Irina here. I find her name just some days ago in our agenda, and it's a very pleasure for me to see her because we have the same experience working with this coalition. And yes, I'll want to return to my speech. When I made it, I based on the report to Ukraine 2023 by European Commission, the last report of Ukrainian Ombudsman, and some other sources, including materials of Coalition Against Discrimination in Ukraine, which I mentioned before. And I want to give you like an overview of the current situation in Ukraine with discrimination based on different grounds, and I'm going to talk about legislation and some practical issues. And of course, the role of European Union in all of this process. I could say that Ukrainian anti-discrimination legislation very much depend from the European Union, and the European Union has great influence to all of the situation with anti-discrimination in Ukraine. The situation is totally opposite that we heard just right now. In the realm of non-discrimination, Ukrainian society demonstrated general openness and tolerance toward the individuals in vulnerable situation. A survey conducted just some months ago in October 2023 by the Kyiv International Institute of Sociology in collaboration with the European Union Consultative Mission in Ukraine shed light on public perception of discrimination in the country. According to the survey, they identified the grounds for discrimination, and the respective percentage include the language, like 45%, sexual orientation, 34%, presence of disability, 28%, age, 27%, ethnicity, 23%, and gender, 22%. It's what Ukrainian population think about discrimination, how much this issue is faced in Ukraine now. To address these concerns and uphold the principle of equality, the Constitution of Ukraine provides protection against discrimination. Unfortunately, we haven't anything directly regarding discrimination in the Constitution, but we have the special article about equality. And it's possible to say that it's include discrimination too. Efforts support the public initiatives and the requirements of the association agreement with European Union led to adoption of the law of Ukraine on principles of prevention and counteraction of discrimination in Ukraine in 2012. It was like a first step when EU started to influence to the legal situation in Ukraine in the sphere of discrimination. And without it, I think any activity from the civil society couldn't be successful. It was like a crucial point which really changed the situation in the country. Although it's considered comprehensive anti-discrimination legislation, the legal grapples with several challenges. Affirmative action requirements are lacking. It exists in the law, but it's very difficult to implement regarding to the law, appending accelerated progress toward equality. For those, the law's alignment with a broader legislative framework post obstacles for victims seeking protection from discrimination. Issues such as the limited range of legal remedies and absence of administrative responsibility for discrimination hinder its effectiveness. Notably, the criminal justice system's lack of corresponding article created loopholes, allowing preparatory of discrimination to evade appropriate punishment over the year. On February 9, 2022, the UN Human Rights Committee expressed concerns its concluding observation on Ukraine's 8th periodical report regarding the absence of comprehensive anti-discrimination legislation aligned with the International Convention on Civil and Political Rights. The committee highlighted insufficient information on measures taken to address stigmatization and discrimination against various groups, including ethnic minorities, LGBTIQ communities, internally displaced persons, and persons with disability. In December 2022, Ukraine enacted the law of media, prohibited the dissemination of video, including hard or discrimination based on various grounds, including national, racial or religion grounds, as well as ethnicity, citizenship, race, religion and belief, age, gender, sexual orientation, gender identity, disability, or any other grounds. The National Council of Ukraine for Television and Radio Broadcasting formalized criteria for identifying such violation and processes the authority to respond to media outlets admitting such infraction. However, concerns persist as reports indicate manifestation of intolerance, prejudice and hate speech in media targeting representative of vulnerable group and minorities. Ukrainian criminal legislation currently addressed hate crimes and hate speech based on three characters: race, nationality, and religion belief. However, it falls short covering sexual orientation and gender identity, recommended as a priority by the European Commission against Racism and Intolerance. A draw law prepared by the Ministry of Internal Affairs is to include these additional protected grounds was introduced to Parliament in 2021, but is yet to be adopted. The national policy of Ukraine implemented a new data collection form to investigate hate crime and offences in the first 2 months of 2023, launching a pretrial investigation into 26 criminal offences based on hatred. However, concerns raised by the committee indicate that the majority of hate crimes against minority groups do not qualify under existing legal provisions. A key recommendation by the European Commission is in Ukraine pursuit of EU membership was the completion of legislation reform to realize the rights of national minorities or communities. Verkhovna Rada, Ukrainian Parliament, adopted the law of Ukraine on national minorities or communities on Ukraine, aligning with the development of a sovereign, independent, democratic, social, and legal state. The full-scale innovation by Russian Federation further complicated the situation, leading to deterioration in Ukrainian attitude toward Russian and Belarusian, which is totally understandable, but it's fact that the situation is became worse and worse. And it's possible like different violation in this sphere too. The Ukrainian Parliament's Commissioner for Human Rights plays a pivotal role in combating discrimination, received 395 reports on discrimination on various grounds in 2022. It operates as independent body with power equivalent to those attributed to national equality bodies. To enhance the capacities of law enforcement and legal and aid system, sustainable training is crucial. Additionally, strengthening the legal aid system is essential for the effective implementation of legislation combating discrimination, hate speech, and hate crime. I want to give you some overview regarding some grounds, and I want to start from gender equality and women's rights and discrimination in this sphere. Ukraine has made strides in enhancing legislation to promote gender equality, including the 2005 law of ensuring equal rights and opportunities for men and women, the 2012 law of principle of prevention and combating discrimination, as I said, and the 2018 law of prevention of domestic violence. Despite this legal framework, they are often seen as declarative, providing limited guidance. To address this, the Cabinet of Ministers adopted a comprehensive 2030 state strategy in August 2022. You could see that a lot of things happened after the beginning of the full escalation in Ukraine, especially in the legal sphere or policy sphere. The strategy focusing on equal rights and opportunities across public institutions, economic and environmental issues. Since 2017, gender policy coordination in the government has been overseen by the Office of Deputy Prime Minister of European and Euro-Atlantic Integration. The Commission of Gender Policy was established to ensure concerted involvement of all executive bodies, fostering of a more effective horizontal approach to get gender equality. However, concerns persist with the UN Human Rights Committee, noting a low level of women's representation in public sector, especially at senior level, and a continuing wage gap between men and women. To address gender-based violence, Ukraine ratified Council of Europe Convention of Prevention and Combating Violence Against Women and Domestic Violence, Istanbul Convention, in July 2022. Despite these efforts, gender-based violence prevention faced a setback in 2022 due to budget constraints and degradation of social services, especially in conflict-affected regions. While documented cases of gender-based violence decreased by almost 50%, in the first half of 2022, the number of non-documented cases likely increased. Conflict-related and gender-based sexual violence emerged as significant issues with hundreds of confirmed cases and an established large number of unreported cases. The UN Committee of the Elimination of Discrimination Against Women expressed concern about gross human rights violation against Ukrainian women and girls during the military attack impacting various vulnerable groups. Ukraine revised the National Action Plan of UN Security Council Resolution 3025 on women, peace and security, incorporating a measure on conflict-related sexual violence. Full implementation requires the inclusion of women in reconciliation and decision-making processes, systematic training for law enforcement agencies and the military, and the detection of violence form within institutions. Justice with gender-sensitive approach, prevention, investigation, and punishment of sexual and gender-based crimes during armed conflict need attention. Efforts include align the legal framework of international standards and establish a comprehensive response system, one-stop response centers, and investigation mechanism. Memorandum of cooperation between the government and UN of prevention and counteracting sexual violence in wartime was signed in May 2022. In a positive development, since February 2022, all positions in the Ukraine armed forces have been open to women. By March 2023, over 60,000 women were serving, many of them on the front line. This shift is accompanied by increased societal acceptance of equal rights of women soldiers, necessitating focused attention of their needs, including equipment, protection against sexual violence and harassment, medical support during and after combat, and reintegration support into civilian life post retirement from the armed force. About persons with disabilities in Ukraine. In 2010, Ukraine ratified the UN Convention on the Rights of Persons with Disabilities, emphasizing a commitment to eliminate discrimination based on disability. The law on the basis of social protection of persons with disabilities prohibits such discrimination and introduced quotas for companies. However, integration into the workspace remains limited, with the application of a reasonable accommodation principle for persons with disability being rare. The national strategy for barrier-free environment in Ukraine, spanning until 2030, aims to empower persons with disabilities and ensure their fundamental rights. The 2023-2024 action plan focuses on monitoring and adaptation the physical environment and transport, aiming for barrier-free infrastructure by 2024, which I think not realistic. Challenges include limited disaggregated data due to outdated registration method and inadequate legal capacity for persons with disability. As in January 2020, 2.7 million persons with disability were registered in Ukraine, a number expected to rise due to the conflict with Russia. The situation is explicitly challenging for those with intellectual and psychosocial disabilities facing high institutionalization rates. Reform to reduce institutionalization have seen limited success, requiring prioritization at the local and regional levels. Equal participation and opportunities for persons with disabilities faced obstacles in transportation, healthcare, social services, and public buildings. Legislation lacks incentive for employing persons with disabilities in open labor market, accelerated by strengths of public services due to the conflict. Some words about LGBTIQ rights in Ukraine. Ukraine has witnessed a positive trend in increasing tolerance and acceptance of LGBTIQ individuals over the last decade. Hate crimes against this community have decreased by 44% since 2020, reflecting social shifts. Surveys in 2022 indicate majority support for same-sex partnership and equal rights for LGBTIQ persons. Exciting legislation such as labor code offers some protection against discrimination based on sexual orientation, with ongoing reforms to ensure equal rights. The media law adopted in December 2022 prohibited hate speech and incidents based on sexual orientation and gender identity. The National Human Rights Action Plan 2021-2023 envision progress, including amendment to the criminal code and drafting law for the elimination of discrimination provision and the introducing of registered civil partnership. In March 2023, a draft bill of the legalization of same-sex marriage, but honestly it's about this civil partnership, was introduced with the government commitment to appropriate by the end of 2023. In June 2023, European Court of Human Rights judgment emphasized the state's obligation to ensure equal treatment for same-sex couples in Ukraine. The government's clear communication in support of LGBTIQ rights and participation in events like Kyiv Pride or Kharkiv Pride contributes to fostering an inclusive society. Another group is Roma minority in Ukraine. The Roma minority faced several challenges in Ukraine, enduring discrimination, anti-Gypsyism, economic and social exclusion, limited access to ID documents, inaccessible education, ongoing segregation, poverty, and substandard housing. Education attainment among the Roma population is notably low, with 24% having no education and only 1% achieving higher education. Okay, empowering women, family planning, children rights, protection, and preventing teens' pregnancies is essential. Addressing misappropriation of the child support funds and discrimination by the police. Okay, maybe I will stop with Roma, and another group is eternal displaced person, which the number of those, it's around 5 million of people now in Ukraine. And there is a lot of challenges with access to social rights, first of all, and a lot of discrimination with housing and even with education. And Ukraine trying to work with these issues, but still not successful. All of these issues and success, which I mentioned, reflected in the last European Commission report, Ukraine 2023. And even more, there is some recommendation for Ukraine about some reforms which Ukraine should provide, especially in the sphere of labor market, employment, educational, social policy, rights of different groups. And one of reform is deinstitutionalization for children and people with disability. In parallel, maybe you know that European Union create another document for Ukraine. It's a Ukraine facility, which regulate future 50 million euro, which European Union promised to give to Ukraine for reforms and surviving. And there is a lot about different aspects of human rights and different vulnerable group, for example, about persons with disability. And again, there is the norm about deinstitutionalization, and Ukraine should provide this reform for children, children with disability and children with high support need, unfortunately without adults, but maybe it will be some additional documents, and all civil society waiting for the publishing Ukrainian action plan, which reflect to this Ukrainian facility too. And what I want to mention that for now, it's a big task for all Ukrainian society and international society who is interested in supporting Ukraine to advocate for non-discrimination in all of these regulational document, because Ukraine is really open to hear European Union and really open to implement best practices and that measure which European Union provide to Ukraine. And I believe in the best future for my country, and believe that the frame which we getting from European country, from European Union, will help us to combat discrimination successfully. Thank you very much.
Now the floor to Irina Tegushova, and just, I didn't say that in the beginning, we do questions and answers in the end, yeah? So keep your questions for everything. Five. I'm sorry.
Good afternoon, everyone. Thank you very much for the invitation. It's a true pleasure for me to be here today and have the opportunity to discuss the EU's promotion of human rights norms externally, because it closely aligns and it's part of my PhD thesis, which I'm currently pursuing. And actually the aim of my thesis is to explore and investigate global reach of EU disability law in Eastern Partnership countries with the case study on Ukraine. Today I would like to concentrate on four main aspects. Firstly, and very briefly, I would talk about global reach of EU law and why I decided to look at the topic of norm promotion, particularly through this lens as a theoretical framework. Then I will look on legal aspects of EU global actorness on the international level and its self-presentation as a global rights advocate, and whether EU has the right to identify itself as such. And after presenting some mechanism and tools to promote disability rights in Eastern Partnership countries, including Ukraine, I would like to zoom in on basically Ukrainian as the case study, and we will look at some manifestations of the global reach of EU disability law in the national legal order. So global reach of EU law is the concept, and its definition is not settled in academic literature yet. For the purpose of my research, I consider it as an effect-based concept comprising the spread of norms, rules, values, standards in third countries. And basically, because it's an effect-based concept, it was a decisive factor for me. Because many other relating phenomena and concepts, which you might be familiar with as Brussels effect, normative power Europe, Europeanization, for instance, they tend to concentrate rather on the process of the rule transfer than on the effects, with the central role given to the European Union and analysis of the European Union than on the effects and analysis what is happening in the countries after the norm is adopted. Before delving in basically in the analysis of the norm transfer process, I would like to briefly share with you the legal foundation for the EU actorness on the international arena. And basically the main article for which legitimizes EU's actions is Article 32 of the CRPD on international cooperation, which calls European Union to support national efforts in the CRPD implementation and also conduct effective measures in this regard. Thus, this article requests European Union to adopt measures with the extraterritorial effect and provides for the obligation for international cooperation. Similarly, European Union has certain commitments to implement sustainable development goals. And as part of these commitments, women and disability has to be cross-cutting issues, and European Union has to consider them while implementing all 17 CDG goals, including Target 17 on enhanced global partnership for sustainable development. On the constitutional level, we have two main articles, Article 21, Paragraph 2, and Article 3, Paragraph 5 of the Treaty on the Function of the European Union, which basically informs European Union actorness as a global human rights advocate externally, and I think alongside Article 8, which was mentioned already here. The treaties do not contain any explicit provision requiring European Union to act externally and promote disability rights. However, the policy framework and I will briefly also introduce it, embeds various provisions which require European Union to act as the global disability rights advocate. For instance, the strategy for the rights of persons with disabilities clearly outlines the EU's role as the global human rights advocate, and not only in trade relations, not only in political dialogue, but also through in humanitarian action, in development cooperation, and with the neighboring countries, and in particular when it relates to neighboring countries and European neighborhood policy. The key visionary document is Eastern Partnership Policy beyond 2020. Within this policy, EU declares that it will support partner countries in the implementation of the CRPD. And here we can see just a selection of the documents. There are many others, external policy frameworks which inform EU action in humanitarian and development sphere, which mainstream disability and require European Union to adopt disability inclusive actions in third countries. So we can see that disability is quite well mainstream in the policy framework. The question is now how it turns these commitments into real actions. So basically, and when it comes to neighboring countries, including Ukraine, European Union channels its norms through two main mechanisms, conditionality and socialization. Both of these mechanisms, they origin from non-legal studies. Conditionality is considered as intergovernmental mechanism which provides for rewards or other incentives in exchange for or on the condition that a third country, in our case Ukraine, meets EU demands. Socialization in its turn is the, wait a second, I will put to make sure I don't overexceed the time. Socialization is in its turn is the mechanism aimed at attaining more long-term results by teaching a third countries EU rules, standard norms. It aims to facilitate the norm adoption by third countries. And here we can see two socialization mechanisms deployed in Ukraine is TAIEX and Twinning. Both of these instruments aim to help Ukrainian public authorities to interpret and to adopt EU law and EU norms and standards and successfully integrate it with Ukrainian legal order. Concerning disability rights, civil society and non-state actors are also considered part as socialization mechanism. And Rosa Balfour, a scholar, she argues that EU considers non-state actors as agents in transport and transfer of EU acquis into third countries, including Ukraine. So yeah, like if we go back to conditionality, we could see that conditionality could be channeled through bilateral tools and unilateral tools. We disregard unilateral tools because they are not applicable in case of Ukraine. In case of bilateral tools, we can see that very often European Union channels human rights norms through international agreement, which are considered as integration type agreement. Those agreements, they include often the article, which you can see here, which can be considered as a human rights clause. It requires Ukraine to respect democratic principles, human rights, and fundamental freedoms. And in case of a serious violation of human rights, EU has the right either to withhold the incentives or rewards, or even terminate the agreement in general. Tools could be categorized into 4 types. It's international agreements, soft law, financial tools, and non-state actors. I'm afraid I won't be able to discuss in details all of those tools, but we can do it during the Q&A. So what is happening if the country decides to accept the norm? And later I will share with you an example what happens when the norm is getting rejected. So when the country, and in our case, Ukraine, decides to accept the norm, there are like 4 types of level of integration of those norms with EU acquis. The first 3 types are more relevant for integration types agreements as association agreements, or partnership and cooperation agreements of Eastern Partnership. It's approximation, convergence, and harmonization. While the last type is more relevant for those countries which already undergo the accession process and basically are the final stage, because it's about direct download of EU norms and direct applicability of EU law in third country before entering the European Union. Let's zoom in now on Ukraine and EU-Ukraine relationship and see the dynamic in regard to disability rights. Primarily, at the early stages of EU-Ukraine cooperation, disability matters were not integrated in the cooperation framework. Neither partnership and cooperation agreement, which was adopted in '94 and enforced in '98, nor the action plan, which was adopted to implement the agreement, they did not include disability rights at all. However, over time, this dynamic changed, and I assume it's due to the fact that both parties adopted and ratified the UNCRPD, the convention which was already mentioned here. Ukraine adopted the convention in 2008, and it was ratified in 2010. For European Union, it was enforced in 2011. So after the convention was ratified, European Union started paying closer attention to what is going on in third countries and how should it act in order to help to facilitate the advancement of disability rights. And we can see it through the progress reports. For instance, in similar reports, EU paid attention to the legislation on the equal employment opportunities of persons with disabilities, non-discrimination, barrier-free access, and in general, it started monitoring the progress made by Ukraine in ensuring that national legislation complies with the CRPD and the optional protocol. The current relationship as we all know, between Ukraine and European Union is based on the association agreement with deep and comprehensive free trade area, which was concluded in 2014. And it's EU claims that it is the most ambitious deal ever negotiated by the European Union, because it includes around 1,000 pages, 44 annexes, and actually 90% of this document is comprised of these annexes. Even though disability rights are not explicitly mentioned in the body of the document, in the provisions, those various annexes which require Ukraine to align its legislation in various spheres, as transport, media, they mainstream disability to a larger extent. And here we come. Here we can see the example. For instance, Annex 37 of the chapter on audiovisual policy on audiovisual sector policy obliges Ukraine to align its legislation with the Audiovisual Media Service Directive. And in order to align with this directive, last year, Maria already mentioned, Ukraine adopted law on media. This law includes anti-discrimination provision, particular Article 33, Paragraph 1, which prohibits to distribute in media and on video sharing platforms statements inciting hatred, hostility, cruelty, discrimination against people on. I know here, like I didn't mention like various grounds, but including on disability as well. And you can see this is the final version of this provision. However, this final version is the result of a very long work, mutual work, and with international partners, because initially it didn't look like that and didn't look that nice. Twice, Ukrainian Parliament requested Council of Europe to provide legal opinion, firstly on the draft law, and after the law was adopted already, in order to seek to advise how to improve this piece of legislation. And yes, of course, a lot of things yet has to be improved, and now the Ministry on Culture and Information Policy, together with the civil society, work together on drafting recommendations how to improve barrier-free access for people with disabilities in media sphere. However, it's already an achievement, and this is the result of the fact that during all stages of norm development, draft implementation, we had international partners, we had experts, we have resources and capacities to adopt this law and start effectively implementing it. Not always it is happening like this. An example of norm rejection could be the failed reform on institutional reform of institutional child care, which it was initiated in 2017, and in 2019 it was put on hold because there was a strong opposition in the parliament against this reform. There was no experts, there was no resources, there was no even the agreement inside the civil society over this reform. And because there was no very effective cooperation of all external partners and involvement, including of the European Union, back at that time, this reform failed. However, now we know that it will be, it will have to restart again, as we are entering a new era of cooperation with the European Union. Here are other examples of approximation with EU disability norms and standards in Ukraine. And all these legal acts were adopted and reform were conducted within the last 2 or 3 years. So what's next? At the moment, end of last year, we received the enlargement package. An enlargement package is comprised of Commission opinion and reports, which indicate the priorities and recommendations for Ukraine to be fulfilled. In disability domain, we have several reforms to be conducted. Primarily, it's deinstitutionalization, because there is a huge problem with that, and we have one of the highest rates of institutional care support. Second, restoring and reconstructing infrastructure incompatible with barrier-free environment standards, transition to community-based care and independent living, and I assume it will be part of the larger deinstitutionalization reform. And yeah, like this I selected only a few examples. The list is not exhaustive. There are many other points which Ukraine has to fulfill in regard advancing disability rights in Ukraine. And I think I would stop here. Thank you very much for your attention, and looking forward to your questions.
And I've seen that Dr. Eben Josef has now arrived, and we weren't there at the beginning. So we're really grateful for her to give a comment, which is entitled, is it time for the EU refocus from non-discrimination policies to acceptance policies? You have the floor.
Actually have slides.
I can just stop. The slides needs to be implemented in those computers at the back.
If not, I can just talk.
Email very fast and I can do it.
Sure.
Worthwhile. Yeah, when even registered for this event, I thought we can't just have her sitting in the audience. She needs to say something. That's why I asked her to do it.
I wanted to come, actually just wanted to come and hear the conversation, but I just want to trouble this matter a little bit, you know, just to trouble it a little bit. It's what I want to just introduce is something I did in my doctorate degree. I looked at the whole concept of acceptance. You know, I think when you ask people, you know, what they want, when they experience ageism, sexism, disability, you know, ableism or racism, you know, they never tell you anything. Most times they always tell you, I want to be accepted. That's what they tell you. You know, people come when they are LGBTQ or, you know, and they have a challenge, they tell you, I want to be accepted, you know. And so it always worried me that, so why aren't we doing anything about it? When I was doing my doctorate, it was so hard to find any material to reference anything. So I literally had to create material. Then I had to ask people, what is acceptance? What does it mean to you? That's what they all tell me. You sit down with anybody who's just had a horrible experience in work or in school, the first thing they tell you, I want my difference accepted. So I'm like, okay, I'm actually asking you, is there a conspiracy somewhere that we're not going to do this acceptance thing and we're going to do racism, sexism, disability, you know, and we won't do this because this is what people say they want? Or is it something that we academics are doing again where we decide what is good? We've decided that we are the experts. So this is how we're going to frame it. And we keep hearing what you're saying, but it's not clicking. We're not listening, you know? So because my research was, do we have it on? It didn't come. You didn't get it? Oh, it's fine. All right. This is just what I wanted to say anyway. Just that I had some slides to show, you know? Yeah, you know, so again, I look at the idea of social acceptance. I look and I describe it as acceptance. You know, everyone wants to be accepted, you know? things like race, they're often framed, in individual acts of discrimination and racism, But but people look at, if when we deconstruct race, and the identity of Blacks in the Western world is linked to two key problems. One, to be automatically recognized as a human being, and then to be treated as equal. So the first thing is to be automatically recognized. So that's what they want. So what I'm saying is, if this is what I want, shouldn't the policies we are pursuing be the policies that will make you do that? So what we're doing is we're pursuing policies of anti-discrimination, right? I don't want you to not discriminate against me. I want you to accept me. I know it sounds like we're saying the same thing, right? But we're not saying the same thing. Because if I focus on acceptance, so that means that if I come to do an interview with you, you have to prove that your organization is accepting. But if you just have to prove that we're not discriminating, you can just give me 3 things. We're not discriminating. But for you to be able to prove that you are an accepting organization, you have to do some work. So to prove that we're not discriminatory is easy to do. Because I look at, and I'm asking myself that, oh, it's up. How do I get to it here? Oh, I can't see it here. Okay. So people want to be, if you go back up a little bit. Yeah. Can I continue from here? No. Okay.
It's on the Zoom meeting.
Sorry?
It's on the Zoom meeting.
Okay. So again, so everyone wants to be accepted, right? I know I have only 10 minutes, so I'll just fly through it, So race is often framed as so, but acceptance is necessary for newcomers to integrate. See, if I come to your house, right, you have to accept me. Yeah, maybe I'm being basic, because that's what I like to be. That's what gets results. And that's why I think it's not working. All of these policies, it's not really working. It's getting worse. I've lived in the EU now, 22 years? I think it's gone worse. And it's even getting worse. We're talking about the far right, it's getting worse. We can talk about what's happening in Ireland. Another building was burnt again. So that means that are we flogging this horse? Are we saying we're going to keep doing, they say insanity is that we're doing the same thing over and over, expecting a different result, but we're doing the same thing. I know it looks good on paper, but I'm saying the people on the ground, are they getting better? The people who come talk to me, their experiences are not getting better. It might look like it on paper, but I'm just saying the people, the human beings who I'm talking to, these policies are not filtering down. So what should the EU really be pushing down? If they're spending money to do this, what should they be asking us as academics to research? What should they be asking countries to do? So, we look at, that, multiculturalism in Ireland or Europe is based on what people can actually offer. So if they can't offer anything, I don't want to spend time to go into things, if we look at Ukraine, we look at what about the other groups, Syria where they have problems, Congo where they have problems, So are we looking at what Ukraine can offer? So is EU looking at what Ukraine can offer to the EU compared to what the Congo? Because the Congo have problems as well, Syria have problems as well. So, so why our responses are different? Is it because can we offer something different? Because that's actually what our EU policies are based on, what people can offer. So then we decide how we respond to you. What's that? So it's not rooted in human rights approach, but dependent on self-perceived altruism or generosity of the host. If you go to the next slide. So, but people actually want, when you ask them, what do you want? They want to be fairly judged. They want to be seen. They want a sense of being a part of a system as insiders, not on the fringes. And they want to be unhampered in the process of fulfilling their humanity. So I'm saying that anti-discrimination policies, do they help us to do those things? When we ask an organization to, when we are asking countries, to have policies that are anti-discriminatory, do they help us to achieve this? I asked people, when I did my research, I asked people, I say, because all of them kept using the word accept, I want to be accepted. I'm like, okay, then let's study this. And if this is what you want, let's study it. Then I asked them, I say, what makes you feel accepted? They told me, they know what they want. But it's something that we do. We are the experts, we are the academics, we know so much, and we don't listen to the people. And that's why things are not working, But these are the 3 key things. They want to be fairly judged. They want to have a sense of being a part of a system and to be unhampered in the process of fulfilling their. The next slide. So from my talking with people, this is what I came up with as my own definition of acceptance. That it is a state or act of receiving someone during an unharmful social interaction as true and valid without imputing judgment. So the key thing is, if I treat you, if I can receive you and not impute judgment on you, I can live with anybody. The reason we have problems is that we impute negative judgment. And so our policies should be policies that are driving at saying, how can we work in a way that we train people, we retrain ourselves, reprogram our system to not impute. The problem there is the judgment. The minute we impute negative judgment, we create a problem. So that's where the problem is. So that's my own definition. So the two main components suggest that the aspect of taking a person as true and valid signifies other people's views and beliefs can be respected without necessarily agreeing with them. So I can, in this room now, I can actually have a very different view from you and be your best friend. Because I permit you to have your view, the same way you must permit me to have my belief system. And that's what acceptance does. That when we can come to a place where we are accepting of difference, it's like, what's so fantastic about you that you want me to be like you? What's so fantastic about me that I want you to be like me? Do you understand? So those are the questions we need to ask. I don't want to be like you. I'm happy being me. And the same way that I don't want you to be like me. We'll be cloned. We'll be looking like zombies, cloned people. So that and all of that. We'll go to the next slide if there's, I think. So what should we teach? Next one. This is what I'm asking. Our attitude to difference. How can we teach this as an attitude to difference? So I'm saying that acceptance is the tipping point. It's a tipping point. If you put a judgment at all, you've gone away from acceptance. So that acceptance is a tipping point. So it's like a scale that if we judge people negative, if you bring in the concept of judgment, if we judge people negatively, you will have to tolerate them. And tolerate is a word I hate because I say nobody lives and say, hey, I'm just going to go to IRL today and look for somebody to tolerate me. It doesn't happen. Nobody wants to be tolerated. So we shouldn't teach it. But I see policies and they say, tolerate. No, don't tolerate. People who write that are people who never get tolerated. You are so respected that word toleration doesn't even occur in your space. So that's why we can ask people to tolerate, But if I judge something negatively, for me to be able to live with that person, the only way I can do that is to have to tolerate them because I'm saying I'm better, I'm stronger, I'm this than you. If we judge them positively, then we have to recognize or respect them. That's it. So you judge them, oh my God, it's amazing. So we're judging it positively. But acceptance is that I'm not going to judge you. I'm going to accept you as a true representation. So it's like black hair, white hair. It's like you're white, you're black, you're blue, you're yellow. You're on a wheelchair, you have a hijab. You accept it as a true representation of the person. So I'm just saying that, is it high time for the EU to go back to the table and look at it? Are we pursuing the right thing? Or should we listen to the people who actually have problems?
Yeah, thank you very much. Now, we are supposed to do question and answers. I did not put a big table here so that everybody can sit in front. But we do question and answers. We had a really big journey with Rory stressing the litigative potential of Article 2 very much. Yes, so it's all enforcing rights through the courts. Going forward to Maria, who also stressed the material dimension, so that it is necessary to provide funds for disabled persons to be accepted in the employment market. That is what reasonable accommodation comprises. Going forward to Irina, who then introduced us to an international law concept and to how the EU exports their norms. And both of these presentations focus on conditionality. And then coming back with our, did I forget somebody? No, I didn't. No. Our final commentator who said, I said initially that the EU can be accused to export something which is outdated because it is based on litigation, on very much reaction and not so much proactive, yeah? And so you put this on another dimension, on a psychological area. So I hope we have elicited loads of questions. I'm trying to moderate, and I hope we get the recording also if somebody speaks from the audience. So, you know, the audience who wants to ask questions needs to know you're recorded as well. So any questions to any of the speakers, please? Oh, no. So, yes. Can you say your name so people know who's asking?
My name is Ana Lucia. I am from Guatemala, and right now I'm a PhD visitor student at UCD. And I study a PhD in Valencia, Spain. And my area of studies is human rights. So that's more of what you asked me. Sorry. My question will be to the last speaker, to you. I've been looking for information about the cultural environment or grief of migrant. I don't know if you have heard about that. The shock cultural that any immigrant or migrant comes with, either be if you flee the country or you come as voluntarily, you have a cultural shock in your process of immersing into the new society you're living. How would you relate that into human rights? Because right now, hearing you about acceptance makes me rethink that some of that could be related to it, because you are trying to integrate yourself into the society, but you also want to be part of the society. So you're kind of losing part of your identity in this process of immersion, right? So how do you, if you can just let me know if you were related, because your acceptance speech is really kind of linking it to me.
And let's see whether we have more questions to other speakers, if that's okay, yeah? Because we only have like 25 minutes for questions and answers. So, and also speakers can ask each other's questions, yes? So you're not excluded for questions, yes?
Rather technical questions.
Yeah.
We don't, you know, can a district court judge refer a case to the European Court of Human Rights on you know, from the district court without going through circuit and high court? Is there a rule that allows it?
You want to take the questions together before?
Yeah, we take the questions together, yeah. That's one question. Yeah, just.
I just want to get, please advise if you do provide legal advice regarding media discrimination, hostility against myself and my children, and basic human rights, essentially the evidence while working for Google, Microsoft.
Is that a question to a specific speaker or just general? Okay, I'll take that one if nobody takes it up. So any more questions? Yeah. We forgot the last person didn't give their name.
Patrick Coyne, how are you doing?
Oh, everybody knows you, but maybe not everybody. Yes.
How are you doing, folks?
My name is Tom Emeka Ogu. I'm a PhD student, law student at the UCC in Cork. My area of research is on enforcement of discrimination in Ireland, on employment law. My question goes to the last speaker here, Joseph, regarding the acceptance. What I want to know, I've read a lot of your articles, and as a sociologist, I know you didn't say much about the legal aspects of implementing enforcement of the anti-discrimination laws. But don't you think that the enforcement area of anti-discrimination laws is the major problem? Because you can, if there is a law and there's no enforcement of that law, the law is useless. So what do you think the impacts of enforcement, effective enforcement, can have on anti-discrimination measures? Thank you.
Yes.
I'm Felicitas. I'm a postdoctoral researcher from UCC, and I would just add on to your question because I had a similar thought by asking, is it even good to have such a law? Because the issue of acceptance, I come from a human rights background, to me is very much one that concerns the inner state of a person, their personality. How do we regulate that in law? Is it good to even try to do so? Because from a human rights background, I would say that's an absolutely protected realm. So it goes down a similar route than asking what is it worth if we have something that should not and cannot perhaps be implemented. Yeah, that's my question. Thank you.
So if there's no questions, I have questions to our Ukrainian speakers, to each of them, but if there's none, anybody else from. So Maria, you mentioned a lot of mechanisms how the EU tries to implement that discrimination law. So it's via reports and the accession process, via conditionality on the funding, and then you said there's also success when civil society gets involved. Can you say which one is most successful of these modes in your opinion? And you also mentioned, I think both of you, and that's why I asked now Irina, you went to the media legislation on anti-hate crime, yeah? So when I have a little bit experience, not in advising Ukraine, but in looking into how Georgia implements the accession agreement and association agreement is very similar. And there I found, and I found that in Ukraine as well, that all that legislation still works on fault. So you need to prove fault for discrimination. And if you go to a hate crime, you move into the area of criminal law. Can you do this without the fault? And can this go into the positive development and the proactive development? That's my question for Irina and the other one for Maria. So now we have questions for each speaker. Do we have any more questions from the online world? No. Okay, so shall we go in the same order where they spoke? So we have Romy first, and then we have you two, and Yvonne last. Said okay. We need to reserve some more time for Yvonne because she had most questions.
So as regards the European Court of Human Rights, there's the Court of Human Rights has different jurisdictions. For instance, recently in the news, we know that there are interstate applications. So Ireland has announced it's going to take a case against the United Kingdom. These are quite rare, but they're often very important. The main jurisdiction of the court are individual applications. So if somebody has gone through all of the domestic courts and their rights have not been vindicated, then they can make an application to the Court of Human Rights in Strasbourg. But that's only after the exhaustion of all domestic remedies before they can make an individual application. Very recently, well, relatively recently, it's also been introduced the possibility for the highest courts in a country, so the Supreme Court, not the District Court, to pose a question to the Court of Human Rights on the interpretation of the Convention rights. So there's started to be some of these advisory opinions coming through, but that wouldn't be possible for the District Court. Conversely, in relation to European Union law, any court or tribunal, Dagmar can correct me, she'll know this better than I do, but any court or tribunal can pose a question on the interpretation of European Union law to the Court of Justice of the European Union. So you have some cases from very low-level courts and tribunals, industrial tribunals in Britain, for instance, going to the Court of Justice in Luxembourg.
I've noticed a lot of cases going before the licensing court in relation to Section 19 of discrimination at the point of entry. Yeah, and I noticed some going through. I have a feeling that they're perhaps going to go from the District Court straight to some European body. But
that would be the European Court of Justice, because that's it's a racist discrimination and people are not admitted to the premises on racist grounds. Then it might be an element of Directive 2043 on race discrimination, and there might be an element of insufficient implementation of that directive into Irish or other national law. Then it could go directly. Otherwise, there's also the complaint procedures, which are not judicial. Yeah, so maybe that's another point to put into.
I'll talk to you perhaps afterwards, Mike, because it's a bit.
That was something I was going to ask you, but I wasn't going to be so provocative. This whole thing about direct effect of Article 2 it's a wholly UK internal affair. Yeah. So, although the courts are surprisingly and welcomingly very proactive and recognize direct effect, if they wouldn't, there would be no EU body which can interfere in Article 2, because Article 12 of the protocol or the Windsor framework doesn't apply to Article 2. That's more a comment than a question. Anyway, so who's next? Maria.
I even don't know what to answer, because last time I worked most with the rights of the person with disability, and the success of our organization and our partners is to have digitalization in all of these tools, like the Ukrainian facility and in reports which support Ukrainian candidate status. And again, this year it will be a report to CRPD, Committee of the Rights of the Person with Disability in the UN. And I think that all of these instruments, all of these tools together could give us like a final result with a real process of digitalization in Ukraine. And in parallel, inside of the country, organization who is working with the rights of the child started to work with organization of person with disability in this direction, and start to influence to Ukrainian authority and to push them to create the institutionalization plan for children. And I believe that in the nearest future we will have the same for adults, for persons with disability.
Yeah, regarding the law on media, which was recently adopted, mostly it relates to media and video sharing platform, meaning that in case of violation, there would be sanctions or other fines or like activities. However, I think the criminal proceeding would be relevant when we have a look at the anti-discrimination law, which Maria mentioned, which was adopted in 2012, which envisaged that for certain actions of hatred and discrimination, they might be a criminal procedure. However, the media itself cannot be liable within the criminal proceeding. Yeah, so it's like more like a civil procedure. However, the law itself includes a lot of positive actions, and there are several provisions which would require media to raise awareness, to develop plans, like 2-3 years plans of increasing the accessibility of content, on raising awareness on disability in Ukraine, which potentially might prevent media from disseminating a hatred and discriminatory statements. As to a larger extent, media promotes it without having knowledge what they are doing, and lack of awareness what is actually a discriminatory content and what might constitute discrimination. Yeah, like mostly what I would like to say that this law on media is very comprehensive, and tries to prevent in the first instance through various measures. And in case of the violation, there will be certain sanctions following.
So it's a proactive approach more than a reactive.
Yeah.
Now, everyone has a lot of work because he has 3 questions.
I think they're very simple, but I will say again, if you've not read my book, please go read it. I have a chapter in there. I talk about, so if you've not read it, read it. You know, and I talk about it there. But the first thing I want to say, you talk about culture shock.
Yes.
So if you read culture shock, the way that it's outdated. Outdated. So because people don't have culture shock the way they traditionally had it. You know, when you come abroad, you're like, oh my God, no, they don't have it anymore because of the web, you know. People who come now from those countries, they are more westernized than us who are here. They know they know the things, they know the accents, they know the media, the television. They are used to it. They are coming excited to live that life. So the culture shock that they used to have then is not what they have now. But what I notice now, the more culture shock that will be. So, for example, you're over there, you're in an African country, you're like, oh, everybody tells the truth abroad. That's what we believe when we're coming. Like everybody tells the truth. Equality is real, and all of those things. There's no stealing, there are no poor people. And then you come and you see people on the street. Then you come and you see that people actually do lie here. And then you come and then you see that actually there's discrimination. You see, that's the culture shock. That is what people are actually having to attune to. But that old one of, oh, I don't know the word, I don't understand it. No, that's all gone. Because of so check it. So if you're interviewing people, check it out and make sure that you're not sitting, that's culture shock of 40 years, 30 years ago.
Well, it's kind of the thing of, they call it the grief of the migrant.
Okay.
Because it's like a grief of the migrant.
Okay.
It's not homesickness.
It's like homesickness. Yeah, like homesickness. It's like people, like, if they flew or they are refugees, they have this, there are more researchers, like psychiatry and psychological research than legal research. I wanted to know if somehow that could be related.
So in my work, what I found, when I talk about the oscillation, but that oscillation comes when, so this piece that I'm talking about, now that oscillation, when they start missing home, because they actually came here, they actually want to be here. They came here with excitement and joy.
The ones that came voluntarily, but the ones that came.
Exactly. Yeah, but even when people didn't come voluntarily, it's still a space. They've come for safety. So there's something they came for. So that still draws them. Is a pull. There's a pull here. So when they come to, I don't mean here, but West, in the West. So when they come, what brings that oscillation is when their expectations are damaged. Okay. Do you understand?
Yeah, I understand.
So it's not because they are drawn to go back home. No, it's that their expectations change. So they come. I have a pattern. I draw. I have a pathway of. So I talk about expectation, and then actually people's identities change because they have expectations. Then they have to navigate the spaces. So when they are trying to navigate it, when those experiences are mainly negative, they start to oscillate. Okay. So it's the negativity of the experience that creates the grief and the desire for home. If they come here and they are able to integrate and they are accepted and they are included, right? They know they can, apart from those who, maybe are like like refugees and can't go home immediately, but because they have a safety here and, they're like 10 needs. So only one need of not being able to go back and you meet all the other 9, they are able to hang on. But it's when all the other bits are not working, they are encountering racism, they are being burned where they are sleeping on the street, I just want to go home. Yeah. Do you see? So that oscillation comes from that. It's when their expectations are not met, then they begin to navigate that. They then have to change themselves, change their identities to be able to struggle to stay. So when they are losing too much of themselves, the grief comes. Okay. That's what's in my research. That's what I wrote about in my own work. Okay. You asked a question. I'm sorry, I'm going to confuse it.
The law, a good way to acclimatize to another culture is through the music. Yeah. If you go to if you're in other places, listen to the music from that place, and after a while, I don't know why it acclimatizes you. Yeah, it's like when you're in Arabic countries, I think, God, we should stop playing that, and then you start getting into it. And that's the same here. You should go to cobblestone or something.
Yeah, we had 2 questions on how far Ebon's concept can relate to legal procedures, if I may. They're totally different, yeah. Felissa just wanted to know how is the law to be changed to achieve the things, and Tom's wanted to know what will enforcement of the law change.
So again, so for implementation, so again, we know that, so racism is my thing. So right, so let me talk from the point of racism. So racism only exists because of 2 things, policy and law. So it's a power system and it's a policy system, right? So if the policies, that's why racism is still here. If the policies were not there and there were no laws upholding it, it would have been gone, it would have been kicked out. but we keep creating new laws. The same states that are saying they are fighting racism keep creating new laws that maintain racism in place. And to really change a racist state, you must change those policies, you must change those laws and make them, that's where you can change it. So when I'm talking about this whole idea of acceptance, so you are only just gone into the space of the psychological aspect, right? That is beyond the psychological aspect, you know, because for example, an organization has to, so if I go for an interview and I said I wasn't given the job, instead of me now having to prove that you discriminated against me, the company actually has to prove that they were accepted. So they have to show me, what did they do? So when we go to court, they actually have to then show what they did that was accepting. They have to actually, so and that's why those laws don't work.
Yeah, that's a reversal of burden of proof in the EU law.
Sorry?
That's what EU law tries to do, with a reversal of burden of proof. If you give information that, well, I've not been employed as a black woman, but a white man has been employed, same basic qualifications, and the employer has to prove why they did that.
But the employer will prove that they did not discriminate against you, and it's easy to do that. I would just say, look, we have 6 people here, 6 of them are black girls. You've employed 6 black girls. So you can, but they actually have to then prove that they are accepting. It's a different, they have to show what the key things that you put in place that make that is accepting of my difference. So that actually puts more responsibility on them. But for discrimination, they don't have to do, they can just show statistics and say, no, we have 3 black people, you know, here.
Well, in the situation whereby they will tell you, okay, we will follow the policies of the company, we have done this, we have done that to make it work, to follow the laws, and no one is following the enforcement of that law.
Yeah.
Because if without enforcement, someone is monitoring that, look, this law is really in place, yeah, and have been complied with. The companies, the legal powers of a company and an applicant, a job applicant, the gap is very wide.
Yeah.
The job applicant cannot just challenge the company. Yeah. And some of them will not even care. What they want is, I want to get a job. Yeah. Yeah. So how is the enforcement coming here? Yeah. And because if the law is not implemented and enforced, the law is not effective.
Yeah. True, because again, implementation is a key thing. You know, we can have beautiful laws, and if there's nobody enforcing it, nobody making it, you know, like, you know, the ordinary person they don't even have enough power to challenge the systems. So again, and that's what comes back to the EU. How is the EU going to put policies in place that actually, you know, policies that actually work to help the masses? You know, but it's still left to the people to go and prove their cases. I get so many who come to me, they're not going. I'm like, look, I'll go to court with you, I'll support you. But they think about it, oh, I'm going to be non-grata, I won't get a job the next time, blah, 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 blah. And, you know, they end up, you know, just say, you know what, I'll just leave it and try and go and apply for something like that. So yes, implementation is the key thing. But if you are implementing a wrong law or a wrong policy, it's as bad as implementation. So there are 2 key things. Yes, the implementation is key, but you must be implementing the right thing. And so that's where my own argument is that we should begin to look into other things like this whole concept of acceptance. When you came here now, the first thing you said was acceptance. I'm like, okay, she just used the word. You know, you started yours, you know, when you asked your question, the first thing you asked, you started from acceptance. You know, so again, so it's all of that. It's so in our mouth, but it's not in our. We should invest in it. That's fine.
This is lots of food for thought for discussing after the event, because it's 5 p.m. I think we need to close in a way. That's always a sorry thing to say. I think it was still interesting, although I'm not sure we concluded on all that external comparison. Mary and myself need to write a little paper about research works, so now we have no problem to write that paper because there's so many holes in our discussion. But thank you for making this a very interesting event. Thank you also for participating actively. We don't always have that. Making your way here. Thank you.